Welcome to Plan On It.
Hey everyone, welcome into an all-new episode of Plan On It with attorney Christopher E. Botti, board certified specialist in estate planning, trust, and probate law. I am your host, Mike Leon. You know, Chris here, he's got more than 30 years of experience helping individuals and families plan for long-term care and protect what they've built. Today's episode, we're going to be talking about what families should do now that the new Medi-Cal rules are officially in place. Chris is going to explain all of this. We're going to start with the high level as well. Chris, it's good to see you as always. What is Medi-Cal? What are some of these rule changes that are now in effect that have had the biggest impact on long-term care planning?
Well, thank you for having me, Mike. It's good to see you also. 2026 starts a dawn of a new era. And basically what's going on is the Medi-Cal program, had an experiment that lasted approximately 2 years. And it was a failed experiment because California got into a situation where they got into a budget deficit. And the changes that they made for the last 2 years where they eliminated the asset test for qualifying for long-term care Medi-Cal, that change led to a lot more people to apply for the program and put a major strain on the budget. And so California had to pare back and go back to the old system that existed prior to 2024. And that system has been in place for a long time. So essentially, we're taking a step back, going to the old way of doing things. And that's not necessarily the end of the world. It's just more complicated, but the planning opportunities are still significant. So it's not doomsday, but we are now taking a step backwards, unfortunately, for a lot of people. And now we have to deal with these old rules that have been in place for a very long time.
So let's expand on that. Now you said it's not doomsday. Let's talk everybody off the ledge. How does the return of the asset limit kind of change the way the Medi-Cal eligibility works compared to the last couple of years, like you mentioned?
Well, basically the application process is far more involved and difficult, and because now the state's going to ask questions about what do you own in terms of assets, and you're going to have to disclose to the state what you own, and it's a far more intensive application process because of that asset test requirement. So people are now going to have to be much more prepared before submitting an application for Medi-Cal and be prepared to disclose their entire asset profile. And so that creates a lot of additional work for Medi-Cal applicants. The other thing that's happening as a result of the changes is the look-back rules have returned. And so people would mistakenly give assets away improperly in order to get below the eligibility criteria so they can qualify for Medi-Cal. Now the state's going to scrutinize those transfers. And basically, if you did it improperly, you're going to trigger what they call a period of ineligibility, which is a penalty for improperly transferring assets prior to seeking qualification for Medi-Cal. So those two are significant changes. I mean, the asset test, major game changer in terms of bringing that back, in terms of how the applications go. And of course, the look back rules also affect qualification. So the system is essentially the same as it was two years ago, but the last 2 years created this, period where it was quite easy to get someone qualified for Medi-Cal, and no longer the case anymore.
So Chris, I guess it naturally funnels into a follow-up. If I'm an existing applicant, what do I do now?
Okay, so this is critical. So every year after you qualify for Medi-Cal, the state will send out on the 1 year anniversary of your qualification, actually about a month prior to your 1 year anniversary when you first obtain benefits under the Medi-Cal program, and redetermination package. And now this redetermination package is going to include all these questions concerning assets. And so you have to be prepared to pass that asset test. And you don't want to wait until the redetermination application arrives in the mail, and then you're left scrambling to try to pass the asset test because you may not be able to do it in the time period in which you have to, submit the application. So what you need to do now for existing Medi-Cal applications, it's critical. I mean, it is absolutely critical that you do this now, is you need to do a self-assessment. You need to determine whether or not you will fail the asset test when that redetermination comes. That redetermination can come this month, or it can come in December later this year. But you don't want to wait until it shows up in the mail and then you're left scrambling. So you have to do an analysis, a self-assessment. I can explain how that works, but that's essentially what the screaming message is for people who have existing Medi-Cal cards who are enrolled in the long-term care program, you cannot wait. You must act now to determine whether or not you will fail, because if you fail, you lose eligibility. And if you lose eligibility, that can be financially devastating. And so you can't just sit on this.
Well, Chris, let me ask you too. I want you to expand on something you just said. But if someone's listening to you right now and they're like, you know what, I think I may be over the asset limit, or I'm not going to pass this asset limit test. What planning options are still available? How does timing affect all this?
Well, there's plenty of planning options, but the self-assessment is critical. So basically, when California determines if you're eligible for Medi-Cal, they basically say some assets are exempt and other assets are non-exempt. And it's the non-exempt assets that you must worry about. So when I do an analysis, when people come to me for Medi-Cal planning, and I'm trying to determine whether or not you would be eligible for Medi-Cal, I have to create two columns, right? And then column A would be the exempt assets. And exempt assets do not count against eligibility, regardless of their value. And then the column B would be the non-exempt assets. And so in order to know if you're over the limit, you need to know what the current asset limits are. So there's three basically scenarios. There's an individual, and that number for an individual is $130,000. So a single person can have up to $130,000 in non-exempt assets and still qualify for Medi-Cal. That's called by the state of California your property reserve. So for married people, it's different. There's two sets of rules for married people. If both people, married people, are on the Medi-Cal program, that asset limit is $195,000. Okay, and then for people who are married, where one person is on the Medi-Cal program and one is not, that asset limit is far greater. It's $287,000 of non-exempt assets. So once you know that bogey, once you know what that number is, then you can conduct your analysis and put your assets in different columns. So for example, there's 5 really big non-exempt assets that people must understand don't count towards eligibility, starting with your home. That's usually most people's largest asset. Okay, your home is excluded, so you can put that in column A. The next big asset for column A is IRAs and pensions. Now, those will go into column A provided you are taking distributions from those assets. So you need to be pulling money out, we call your required minimum distribution if it's an IRA, in order to exempt that asset. If it's a pension, you need to be getting paid out. So that's exempt asset number 2. And then household goods and personal effects don't count towards eligibility. So you can keep that in column A. Number 4 on the list is a vehicle. You can have one vehicle, whether it's a $500,000 diesel pusher motorhome or a used Toyota Camry that's worth a couple $1,000. You get to keep one vehicle, whether you're single or married. So that goes in column A. And then finally, term life insurance, that doesn't count. So regardless, if you have a $1 million life insurance policy, it doesn't count towards eligibility. Everything else, you got to move over into column B. Now, in my ebook, I put a very detailed explanation because there are more examples of exempt assets and how to conduct this analysis, but you must do this. Now, what you need to understand is there's a myth out there, and that myth has been, well, you can only have $2,000 in your name to qualify for Medi-Cal. That has never, ever been the case. And so that people think that's the case, and therefore they believe that they're all hope is lost. Okay, you can see just with the list of exempt assets that I gave you, the 5, it's rather significant. You can have a lot more than $2,000 in your name and still qualify for Medi-Cal, but you got to focus on that non-exempt column. And if you're over those limits, you are going to fail the asset test. Now, if you do fail, like if you're going to fail, you project out you will, there are things that can be done to prevent that from happening. And those strategies, and there are a multitude of strategies. It's not cookie cutter. Every situation is unique. When we do this for a client, every situation is unique. So there are a multitude of planning options, and those are kind of set forth in my ebook. So, but you can't do these quickly anymore because of the look back rules returning. So now you've got to do it in a methodical way, and it takes time sometimes, especially if you're significantly over the asset limit. It takes time to make these transfers correctly so you don't trigger the look back rule, so you don't trigger a loss of eligibility. So it's rather complicated, it's rather intimidating, but with proper help, you can navigate this. There's hope. You can still preserve eligibility, but don't sleep on it.
Well, we're gonna put the links in the show notes here to the book and things like that. I did want to ask you because you just kind of mentioned I was going to ask you to break down, itemize for me the assets, but I want to pivot to something you just said about the look back rules. So, with that returning, how does that influence decisions about transfers, gifts, or for someone planning to apply to this?
Okay, so let's explain the look back rules briefly. So exempt assets, you can transfer an exempt asset without triggering the look back rule. So for example, if your home is exempt, you theoretically could transfer that home out of your name, and that would not trigger any penalty or look back rule issues. It's the non-exempt assets where the look back rules basically apply. So if you were to transfer in excess of what they call the average private pay rate, which is what a nursing home in California typically costs on a monthly basis, I'm going to round down a little bit. That number changes every year for inflation. But for right now, let's just say it's $13,000. It's going to go up soon, but let's say it's $13,000. If you wrote a check to someone for $14,000, you would then trigger a penalty. And the state would say, look, you gave away $14,000, therefore you're going to lose. They perform a calculation, and I'm not going to get into the weeds too much on this, but they perform a calculation, and then you'll lose at least 1 month of skilled nursing coverage if you're in a nursing home. And that's like expensive. There's a $13,000 mistake you just made. Now, if you go bigger, let's say it's a $100,000 check, then you're triggering a significant period of ineligibility. So there are techniques available that allow you to transfer assets from column B, the non-exempt assets, to column A in a way that's not going to trigger the look back rules. Now, elder law attorneys, much like myself, and I don't particularly care for that term, but that's what we're called, for lack of a better way to describe it, have been doing these techniques for years. And prior to the rule changes 2 years ago, we had to deploy these techniques on a regular basis to get people qualified, to get assets from column B moved over to column A. And so it's a multitude of options are available, but that's essentially what needs to be done.
Chris, as we put a bow on this episode, anyone that's listening to this, maybe they feel a little overwhelmed by these changes or what you just said. So what are some of the most important areas that they should start reviewing first to avoid these surprises later on?
This is where like self-help or like if you're trying to self-medicate and go on the internet and say, I have this condition and I'm going to go, I need this prescription. That would not be a prudent thing to do. It is intimidating. It's very difficult for lay people to navigate this area without professional help. And the state of California, although they do publish information about the program, how to qualify, they're not going to give you a roadmap. There's no desire for them to do so. They prefer that you would spend down your resources to a point where you're essentially bankrupt or almost broke before seeking eligibility, because that keeps more money in the state coffers. So they're not going to tell you what to do. So it is intimidating and typically beyond the scope of understanding for the most average people. And so it's really important you get professional advice. And you really need to see an elder law attorney that focuses on this area, because there are others out there who are called Medi-Cal specialists that are not lawyers, who trade in this industry, and they're not really qualified to properly do this correctly. So you got to be very careful in who you seek advice from. There's a ton of misinformation out there on the internet. Some of it is from people who are financial predators, and their intentions are not well at all. They're evil. And the others are just bad information, like using AI, for example, to try to solve this problem. It's too complicated. Unfortunately, that's the system. All right. Do I like it? Not necessarily, but this is why people like me exist, because it's that intimidating, that complicated. You truly need to get a professional in order to properly navigate it. Because if you make a mistake, it could be devastating. You can lose eligibility. You can lose eligibility for a period of time. And then you're writing checks to the tune of roughly $15,000 a month, because the statewide average may be close to 13, but most facilities charge more than that in the regions where you'd want to be in. So, just be prepared and seek professional assistance. That's how you navigate this correctly.
Listen to the experts. Chris, I can't thank you enough for breaking this all down and giving us time and the insights. I appreciate it as always, my friend.
I appreciate you. Thank you, Mike, for everything. It was a pleasure speaking with you today.
And that's it for today's episode of Plan on It with attorney Chris Botti. If you want to access more resources, you want to connect with Chris, you want to get the 2026 Medi-Cal ebook and upcoming estate planning workshops, advice, do me a favor right now, visit bodylaw.com. Before you go, also like, subscribe, leave a review and comment, or share the episode with someone who needs to hear it. As always, I'm Mike Leon. We will see everybody next time.
If you're enjoying Plan on It, be sure to subscribe, leave us a 5-star review, and like the post. Share or tag friends and family who could benefit from clear, practical estate planning guidance.